Well, hello everybody, and thanks for joining us. I'll give you a second to get tuned in. Hi, Dan Stein here, President of the Federation for American Immigration Reform, and I'm glad to be here, and I'm joined today by our esteemed Executive Director and General Counsel of the Immigration Reform Law Institute, Dale Wilcox. And we're here to drill down on the Supreme Court's departure from several hundred years of precedent in the shocking decision that was issued yesterday, Sessions versus Dimaya, a case that came up from the Ninth Circuit Court of Appeals that suddenly decided, after many, many years, that a deportation statute that seeks to ensure that criminal aliens whose crimes may involve or could involve conceivably violent behavior or use of force and violence was somehow void for vagueness. Void for vagueness, as the court put it. The most remarkable thing about this particular case was it wasn't Anthony Kennedy who joined the liberal justices, and it wasn't John Roberts who joined the left wing of the bench. But instead, after an entire year and a half of watching one court after another engage in unbridled judicial activism to suddenly challenge everything the Trump administration is trying to do, to strike down on the basis of newfound constitutional rights, the executive branch's ability to use its discretion to exclude various aliens for various national security reasons, all of a sudden we find the constitutional doctrine of void for vagueness, a limited doctrine generally applicable in criminal law proceedings, applied to deportation. Now I have our Facebook page pulled up, and as always, I am thrilled to be able to comment, to respond to your comments. And we'll do that when you provide good and interesting, pithy commentaries. I know you have a lot of questions about this case. The significance is remarkable because it means felons, people who have repeatedly done things like breaking and entering in homes and other kind of repeated violent, non-violent behavior that might have led to violence, might not be deported, even though the Trump administration is working very hard to deport alien criminals right now. The pure and total sweep of this decision is not entirely understood, but it's safe to say that the president is shocked by Neil Gorsuch's joining of the majority opinion. He wrote a concurring opinion with the majority, which was the major opinion written by Justice Kagan, who was appointed, of course, by Barack Obama. Did not add much to clarify his position on that or help distinguish it. So we're going to actually spend a little time looking at this decision and talking about its significance for immigration enforcement, criminal alien removal for the future. So thanks for joining me, Dale.
Thanks for having me.
So you've had a chance to look at the decision. What would you say the key takeaways are right now?
Well, as you noted, it's very disturbing that the court applied the same standard it applies regarding void for vagueness and due process in criminal proceedings to civil immigration proceedings.
So the basic principle is, in criminal law, we're both attorneys, just so you know. Don't hold it again. No. In criminal law, theoretically, somebody committing a crime should be able to know or be able to ascertain the essential elements of the crime before he or she commits the acts. That's the principle. And if the statute that Congress passed or a state legislature has passed is so vague and unclear, it prevents arbitrary government power to throw people in jail when that person couldn't actually figure out whether what they did was a crime or not beforehand. That's the void for vagueness doctrine. It's a Sixth Amendment substantive due process.
Fifth Amendment
substantive due process consideration.
Correct.
And for the first time,
now the court's applied it
they're applying this now to civil deportation.
Correct. And it's always been understood that the sovereign can remove whoever they want. Due process is what Congress says they have, and Congress clearly said here that aggravated felons, and more specifically, there are 20 categories of what constitutes an aggravated felon. This particular provision that was stricken concerns the crime of violence category.
Right.
And Congress legislated that anyone who commits a crime that posed a risk of some type of violence, they didn't actually have to commit violence on someone, posed a risk of violence, is deportable. And this court said, well...
let's look at the provision that was at issue.
Right.
Because there's a bunch of enumerated provisions that are clearly called aggravated felonies. And those things are all laid out, so they're pretty clear. I mean, if the state law mirrors approximately the law in the federal statutory definition, they're about the same. You fit that definition, you're out of here. There's no discretion. But they left in this second clause, and that's the clause that was at issue in this case.
Correct.
And the exact language is any other offense that is a felony, and that by its nature involves a substantial risk that physical force against the person or property of another, person or property, okay? Physical force against person or property, okay? Dimaya, the alien in question, had repeatedly burglarized people. That means breaking and entering at night, potentially using physical force, breaking windows or whatever, in a kind of crime where it's foreseeable that if somebody's in the house, there might be violent behavior against a person, but there's certainly going to be violence against property of another may be used in the course of committing a crime, okay? So this provision, any other offense that's a felony and that by its nature involves a substantial risk of physical force against the person or property of another may be used in the course of committing the offense, okay? This, Neil Gorsuch and the four liberal justices, Ginsburg, Kagan, Sotomayor, and the fourth, basically said void for vagueness, all right? Now, Dale.
Yes.
What is the difference between a civil deportation hearing and a criminal proceeding? In other words, is deporting an alien a punishment in the same way that throwing an alien or anybody in jail is considered a punishment?
It's not. And our case law is clear.
So deporting is not a crime.
Correct. It's the sovereign deciding who can stay. And case law is clear on this. It is not a penalty, a punishment like you would have in a criminal proceeding. So obviously the same level of due process, void for vagueness doctrine should not apply to a civil context.
In the context, so you have a difference between civil and criminal proceedings, okay? Deportation is civil. So the protections that might apply in a criminal context do not necessarily, historically do not apply in a deportation context. It's no different than applying for any other civil benefit, the right to remain. So in other words, sending somebody back to their home country where they're a citizen of that country, where they have all the rights and privileges of citizenship, removing them from our jurisdiction is not the same as criminal conviction and penalty. Now, did Gorsuch, in his analysis, make that distinction? Did he accept the government's argument? Historically, 200 years, civil immigration proceedings are not to be treated as the same as criminal proceedings.
No, he didn't. He sided with the four liberal judges.
So why? What gives?
Well, he, in his opinion, looking at precedent, felt that...
what precedent?
Well, you know...
Scalia?
This is...
Scalia would never have found this void for vagueness.
You're right. A judge, they can determine before the case is actually, the opinion is written, they can say, this is how I want the opinion to turn out. This is what I want to see happen, and they tell their law clerks, go find the precedent. And so
Gorsuch did that. I mean, I believe that Ginsburg did that, but not, and Kagan may have done that, but not Gorsuch.
I'm afraid he did. Yes.
Well, that's shocking. I mean, this is a Trump appointee. So what are we supposed to expect from Trump appointees in the future on the bench? This kind of flawed analytical analysis. Let's look at this question of foreseeability for a moment. The substantive argument about a criminal conviction based on void for vagueness is that the person was not able to ascertain what they did that caused them to be deportable, right, to be thrown in jail beforehand. It's about, did I know what the essential elements were before I committed them? That's why we're all entitled to know what the elements of a crime are before we get thrown in jail, right? Now here's the question, Dale. In the civil context of immigration, can Congress change the law and apply it retroactively to an alien who's here, for example, as a green card holder? Can Congress turn around and change the law after the fact, saying aliens who commit these various acts or crimes are deportable?
Well, Congress has total authority over immigration. They absolutely can set the standard.
But the point is, can they change the standard, and can they apply it retroactively? This is important to think about. In other words, the question about foreseeability, is it relevant in the context of Congress's ability to actually change the rules of the game and apply them retroactively so that an alien could be deported for things that person did years before Congress changed the standard. But as long as that person remains an alien, could they then still be deported under these new rules?
Well, in the criminal context,
No.
no.
But in the civil immigration context?
Yes.
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 Therefore, why would an alien necessarily be entitled to a priori knowledge?
Right.
I mean, so we're supposed to believe that Dimaya was sitting there with his hammer, right, getting ready to break into this house, thinking, well, maybe if I run into somebody, I'll kill them with my hammer, but if I don't run into them and only break the window, well, maybe that won't be considered deportable, so I'll try not to kill somebody on the way in because I don't want to be deported, so I'm going to make sure I don't kill anybody. I mean, was that analysis going on?
Yeah, I mean they were.
That analysis was going
well,
on within the criminal with the alien.
Oh well,
Dimaya?
Yeah. I mean, no, the alien wasn't thinking that, but the judges, in their analysis of the opinion, their opinion, they absolutely were doing this. That
was there any facts in the record? You probably haven't seen the record.
Yeah.
You and I can stipulate.
Yeah.
There are probably no facts in the record that said Dimaya said,
yeah.
I wouldn't have burgled this house if I'd realized it might have been a substantial risk of violence against property, right?
Right.
So, is there anything else? Let's add something else. You had some things to say about the case that maybe I'm missing.
Without getting into the weeds here on this case, the court came up with this standard when they're analyzing the aggravated felon statute, and they apply the standard called the categorical approach. Okay, so they don't look at the underlying facts of the case, what Dimaya did. Instead, they
even his intention or perception.
Exactly.
At the time,
so what they do is
Clarence Thomas said you would want to do.
Absolutely.
Right?
So instead, what they did was they created what's called the categorical approach. So they looked to federal law and they looked for a general definition of burglary instead of looking at his specific conduct, because the court has insinuated that it might violate the alien's Sixth Amendment right to a trial by jury to look at the specific facts of his case, to have the immigration court look backward to his conduct, okay? Because you would have an immigration judge ruling over the case instead of a jury. Mm-hmm. Well, here's the catch. The Sixth Amendment does not apply to immigration. The Sixth Amendment applies to criminal cases.
Right.
So the court got it wrong again. They've come up with this categorical approach standard that they say is required by the Sixth Amendment. And then they even twisted it more in this case, made it even more convoluted, and then in the end came up with this ordinary case standard. Can you imagine an ordinary case of someone committing burglary? Would there be a risk of someone getting harmed?
Yes. In all cases, yes, because you don't know who's in the house.
We would say that, but the court...
But it also says person or property. The point is, how do you commit a burglary?
Exactly. Without damaging property.
The universal common law statutory definition of burglary is you're breaking and entering.
But here we have 50 states who have different definitions of crimes. In California, where this crime was committed, apparently... Gorsuch cited a door-to-door salesman conning his way into your house and selling you a sham product could be defined as burglary. So you have that extreme. Then you have someone who actually breaks into your house at night and what we typically think of burglary. So he says, how are we supposed to apply this?
That's not true.
This
burglary
statute
is not somebody getting in by fraud in that way. It's theft.
Well,
burglary is at night.
Yeah. California, apparently their statute's broad. I don't know the specific statute, but he gives this example. So how can we envision the general crime of burglary? How would this person know it was wrong? It's crazy.
Well, so they ultimately, the big issue here is whether the court was willing to defer to immigration judges to make the call on whether somebody had committed a deportable offense, even though this is, in my view, pretty clear statutory guidance from Congress. Same court, by the way, Justice Kennedy, which approvingly said that the Morton memos under the Obama administration gave the Obama administration all this latitude to not enforce immigration law, apparently, and ignoring the very clear statutory commands of Congress. So in the end, what does this ultimately do to Congress's ability to stipulate criminal? Well, first of all, the first issue is what does it do to Trump's ability to remove criminal aliens? We're still
Well,
analyzing that, I think. But
Yes, but obviously it's a subset of a category under aggravated felony. So it's I've seen reports that the provision regarding aggravated felons has been struck down. No, that's not true. It's, as you read before, it's just a subset of one of the 20 categories. So it's not that extreme. However, it does diminish DHS's ability to remove criminal aliens. But it goes further than this.
I think the White House is even more explicit. I mean, they said it was a major loophole.
Sure, right.
And intimated
Right.
that Congress needs to act now.
Right.
Now.
But to go even further, this provision that was struck down is within the criminal code. It's not, it's a definition in the criminal code. It's in 18 U.S.C. 16.
Yeah.
So this is going to affect a lot of other areas, not even just immigration. So
But why put it in the criminal code if it's really a civil deportation matter? Why isn't it included?
well, what happened is the drafters of the aggravated felon provision just incorporated by reference a definition that's already in the criminal code. So they just referred to it. That really has no distinction here. But for immigration purposes, the court struck that definition down.
So in the end, is Congress supposed to actually sit down and have hundreds and hundreds of code pages that are supposed to list every state
You're absolutely
statutory provision that they want to be within the ambit of deportability for state-level criminals?
That is the result of this decision. That's what Congress would have to do to fix this. That's the result. Now, Justice Thomas, we discussed the categorical approach that the plurality used. Justice Thomas says in his dissent, you don't need that. We didn't need it here. You just look at the underlying conduct. First of all, the Sixth Amendment doesn't apply here in the immigration context to an alien.
It's kind of key, okay? I mean, the
It
point
is key.
in grafting.
Yeah.
I mean, you saw in the travel ban cases in grafting First Amendment principles that might apply domestically to immigration selection criteria, either with Congress potentially, or certainly in the case of the travel ban with the president. This is unprecedented, applying these. I mean,
Right.
This is areas where courts have traditionally bugged out, okay? Not my business, plenary power of Congress, delegated to the president, part of the attributes of sovereignty. This unprecedented interference in the judiciary, basically trying to rewrite our immigration laws, has now become a common feature of the American landscape. And the point is, every time the Supreme Court takes away from Congress powers and authority, they're basically taking away the rights of the American people, frankly, because Congress represents the American people. And the judiciary is not responsive to anyone. And how well Donald Trump is going to be able to fix these problems, we're probably going to see a lot of additional crime in this country that would not have happened because recidivists, perpetrators, repeat offenders are not going to be deported because of this court decision. No accountability. Same court that gave us Plyler versus Doe in 1982. Everybody here illegally gets a public education. You wonder why it's so hard to control illegal immigration.
Mm-hmm.
And we're going to have to work on Congress to try to fix this. I mean, in the end, it feels kind of like aliens are making it very hard to deport aliens, aren't they?
Oh, absolutely. But you have how many open borders attorneys on the other side, the ACLU, whatnot, all working to bring these test cases. They've been working on this for years. And in fact, I saw one open borders group who wrote a brief in the Ninth Circuit stating that they've been working at this for 6 years. So they chip away.
So, Dakota Gates is talking quite a bit here, and sounds like her view basically is, well, if you have a timeout on most immigration and stop illegal immigration, you can solve the problem by not letting them in the first place. I think that's pretty much a
That's a
thumbnail
given.
analysis of Dakota's position. Most people are saying, well, if you know they're criminals, you should never let them in the first place. We need tight statutory standards. Adam Rudder says, why don't we just have the right to vote in Mexico? And he says, give illegal aliens the right to vote at this point. What's the difference? I like Adam. He's full of it, but he's fun. Well, you're certainly making your views known, Bob Simmons. Appreciate that. Appreciate your comments. Harry Miller, you break the law, you deport people. So what if Congress actually passed, final question, suppose Congress passed a more generic, if you violate any state law, any felony at state law, you're deportable.
They could do that.
Wouldn't that make it simpler?
They could do it.
Just raise the standard and raise the bar.
Absolutely.
All right, well, we're going to be working on this case some more and trying to advise Congress on some of the ways to close the loophole. I really think this is something that you come to FAIR and, of course, the Immigration Reform Law Institute, early.org, if you haven't checked out their website, for the latest in legal information and news on the immigration reform battle. fairus.org and, of course, early.org is your place. And thanks for joining us, and we'll see you next time.